Good afternoon, everybody. Thank you for joining us today. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society. I'd like to welcome you to today's preview of the 2009-2010 Supreme Court term. For those of you who may be unfamiliar with ACS, we are a national network of lawyers, law students, policymakers, and judges dedicated to promoting the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. And though we're still in September, this Supreme Court term is already off to a notable start with the oral argument 2 weeks ago in the case of Citizens United. And there is so much more to come. The court is set to consider what may well be landmark cases on separation of powers, the First Amendment, standing, takings, and juvenile life without parole. And the court has cert petitions pending in 2 key Second Amendment cases. This term is also significant as the first for Justice Sotomayor and the first full term for Solicitor General Elena Kagan. In short, there is much to keep court watchers busy. And we have an extraordinary panel of experts here today to give us their insights on the coming term. Michael Carvin of Jones Day, Pamela Harris of Georgetown Law Center, Doug Kendall of the Constitutional Accountability Center, Lisa Kung of the Southern Center for Human Rights, Deanne Maynard of Morrison and Foerster, and Paul Smith of Jenner and Block, who is a former board chair and current board member of the American Constitution Society. Our moderator for today's event is Tom Goldstein, who likely needs no introduction in this crowd. But for any newcomers, I'll mention a few highlights. Tom is a partner at Aiken Gump and co-chair of the firm's litigation and Supreme Court practice. He teaches the Supreme Court Litigation Clinic at Stanford and Harvard Law Schools, and he has been principally responsible for SCOTUS blog since 2003. I can think of no one better to guide us through the upcoming term. Tom.
Well, thanks so much. It's so great of you all to take time out of your day and come and talk with us about the Supreme Court. Let me give you a sense of how it is that we're going to structure this. As Caroline mentioned, we are so fortunate to have such great leadership at ACS. We are going to start with what just happened, and that is an extension of the court's last term, where the court heard re-argument in the big campaign finance case. And then we're going to talk about a whole range of cases and bracket that with a discussion of a couple of cert petitions that are pending now and that the court may take involving the incorporation of the Second Amendment, so the big gun questions. In between those two, we're going to talk about a whole bunch of cases. And the court has agreed to hear a lot of cases, around about 50 or so. And so that means in the hour and 15 minutes that these folks are going to talk before we stop in order to take questions, we have a lot of ground to cover. And so we're not going to do 3 cases in a ton of depth. We are going to try and give you a sense of what this group collectively believes are the most interesting things, the things that will have the greatest impact on Americans' lives and that are most important to the values that ACS embodies. We're going to try and generate some debate so that on a couple of these cases we have some opposing viewpoints, and we're going to try and set that up. For other questions, we're going to have individual speakers talk about bodies of cases. For example, 2 different sets of discussions of big criminal law cases this term. We're also going to try and talk about the impact of Justice Sotomayor, the possible retirement of Justice Stevens, the effect of the Obama administration coming in at the Supreme Court. And so we have a huge amount of ground to cover. So we're going to start with campaign finance. For a long time, since the beginning of the last century, the rule has been, Congress has articulated a rule and passed statutes that limit corporate participation in elections, how much money companies can spend. And there are electioneering communications rules that the Supreme Court recently upheld that talk about in the 30 days before a primary, the 60 days before a general election, how much companies can participate. That is front and center in the Hillary case that the Supreme Court heard oral argument in a couple of weeks ago. And we are going to have a discussion about who's right and who's wrong. Doug Kendall is going to try and destroy free speech in elections, and Mike Carvin is going to try and ensure that corporations can buy elections. And between them, we will get to the truth. So maybe, Doug, can you give us your sense on how it is that the Supreme Court ought to come out, even if it's not maybe how the court is going to come out?
Right. Well, I mean, there's a 1990 case called Austin versus Michigan Chamber of Commerce. It's a 6-3 ruling. It was joined by Chief Justice, then Chief Justice Rehnquist, and it distinguishes between speech by corporations and speech by individuals, saying that the, quote, unique state-conferred corporate structure that facilitates the amassing of large treasuries warrants the limits on campaign independent expenditures. And that's really the line that is at issue here. That the first time this case was argued in the spring, it seemed like a pretty minor campaign finance case. Now it's really a huge First Amendment case about whether corporate speech should be treated identically to speech by we the people. And the argument we make, Constitutional Accountability Center makes in our brief, going back to the framing and the words of the Constitution, which use the words persons, people, and citizens, but never use the word corporations, and running through the progressive era and the 17th Amendment that was passed in response to the concerns of the corporate influence on the selection of senators, which is then done by state legislatures. We argue that the distinction, which has been a fixture of our law for a long time and was recognized in Austin, is completely consistent with first principles, and that the court's conservatives, if they overrule Austin, will not only be unleashing corporate campaign expenditures and corporate efforts to control elections. And just to give you a sense of that, ExxonMobil alone had $45 billion in profits in 2008. The Obama and McCain expenditures totaled less than $1 billion. So if ExxonMobil diverted 2% of its 2008 profits to electioneering communications, they could have outspent both campaigns during 2008 and fundamentally distorted or changed the election process. And so we argue that the court's conservatives would be not only unleashing corporate influence on election in blatant violation of the will of the people expressed through statutes we passed over the last 100 years, but also violating the text and principles and history of the Constitution.
So, Michael, how can you live with yourself?
If this didn't have campaign finance attached to it, no serious person would even think that Congress can pass a law saying you can't criticize congressmen when they're running for re-election or the president. That's what this law says. And the answer is just, it's the C word. It's corporations. And as Doug pointed out, the court said, we're giving all these state-conferred benefits to corporations, so as a quid pro quo, we can take away their free speech rights. Does anybody in this audience believe that? Does anybody in this audience believe that tomorrow Congress could pass a law saying MSNBC and the Washington Post can't endorse somebody for president or Congress? We're not interfering with anybody. We're just telling them they can't spend money on newsprint or their broadcast stations, and they're owned by GE, and they're corporations, and they've got all this wealth. Does anybody think that would pass muster because of the framers didn't believe corporations were persons? No hands. And why would it be any different in the campaign finance context? When you hear the word corporations, Doug keeps talking about ExxonMobil, but what he doesn't tell you is the law applies to all corporations, the ACLU, nonprofit corporations, the NRA, who are solely designed to advance citizens' views on important public policy issues. And I don't think eliminating their core political speech rights can be reconciled with any language of the First Amendment or basic understanding. Don't take my word for it. Solicitor General wouldn't defend that nonsensical view that was advanced in Austin. They did not defend the notion that corporations got all these state-conferred benefits and therefore it was okay to limit them. They went off on the notion that corporations would somehow inherently corrupt politicians because they would extract all these promises in exchange for independent expenditures. The problem with that is, of course, it bumps right up against Buckley, which says that if you're not coordinating your independent expenditures with the campaign, there's no possibility of corruption or this quid pro quo that has been used to build this edifice of destroying free speech rights. Does anybody believe that Barack Obama feels some debt of gratitude to David Bossie and the Citizens United because they wrote a book attacking Hillary Clinton? Do you think he might feel a little bit more indebted to huge media corporations who are spending all kinds of money to support him and which, not coincidentally, are exempted from this restriction on corporations endorsing candidates? You think he might feel a tad more indebted to George Soros, who spent about $26 million in trying to re-elect Barack Obama? Or do you think he's really getting Bossie into the Oval Office and consulting on his views because he wrote a book attacking Hillary Clinton? There's 26 states that don't restrict corporate expenditures in state elections. There's not a scintilla of evidence that those states operate any differently than the 24 that do. So normally we try and think that if you're going to restrict free speech, you should have some evidence and you should try and tailor it to the real problem. None of which was done in the campaign finance context. And my final point on this will be, it would be one thing if we were eviscerating Americans' basic rights to participate in the political process if it was designed to achieve some statutory public policy goal. We are doing this in the name of preserving McCain-Feingold. This law was passed 7 years ago to eliminate money from politics and special interest influence over Congress and the president. How many people in this room think that that's been a stirring success, that money's been taken out of Washington? So this law, which is an abysmal failure from the beginning, is being used to ever ratchet up greater and greater state control over citizens' abilities to participate in the political process. And I don't think that First Amendment rights can be sacrificed on such thin empirical evidence.
So
that's how I live with myself.
Doug, you hate the ACLU and you love Fox News, is what I learned from my friend Michael. And how can you live with yourself?
Well, a couple of points. One is we also, the First Amendment also includes something called a text about the freedom of the press, which I think answers the question of why the New York Times can have a position on elections where ExxonMobil doesn't necessarily get all those rights. And second of all, I mean, again, and this is brilliantly laid out if anyone wants to look at it in an opinion by Chief Justice Rehnquist from 1976 in a dissenting opinion called Bellotti, which is why he joins the Austin majority. There is no history whatsoever for giving corporations, in the framing era, in any area of this country, for giving corporations the identical First Amendment rights that individuals have. It is a government of we the people. And second of all, we have passed amendments to the Constitution which are specifically about making sure that our election process is a democracy that protects a government of we the people. That's what our republic is about. And so this case raises just fundamental questions about who our Constitution protects and what our Constitution is about. And I'm happy to stand on the side of we the people and against we the corporations.
We're short of 30 seconds. Two key words in Doug's point were Justice Rehnquist's dissenting opinion in Bellotti, where the majority made clear that corporations do have full First Amendment rights. And number two, excuse me, this notion that the free press somehow entitles media to special protections has been rejected by the court by approximately 4 times. The free speech restrictions that you can impose on others can also be imposed on the press.
All right, well, let's stick with the First Amendment, because there's more going on there than just campaign finance. we have both free speech and religion-related cases. And so, Paul, could you talk about those?
Sure. Thanks, Tom. Let me start by talking about United States against Stevens, which is an interesting case because it's one in which the United States is asking the Supreme Court for the first time in more than a quarter century to recognize a new entire exception to the First Amendment for depictions of animal cruelty. 18 U.S.C. Section 48 makes it a crime to possess or distribute or sell a film or movie that depicts animal cruelty, defined as anything that shows a living animal being maimed, mutilated, tortured, wounded, or killed. If the conduct was illegal, either where it occurred, where it was filmed, or where you happen to have the film, even if it was legal where it occurred. So, for example, a bullfighting video might be subject to this law if the bullfighting happens to be illegal where you own the film. It does have an exception for depictions with serious religious, political, scientific, educational, journalistic, historical, or artistic value. So there's about 1 million different details to the way this law is constructed, but they did apply it to Mr. Stevens, who had films about dogfighting, which he was old films about dogfighting, and Japanese films of dogfighting, where apparently it's legal, that he was distributing. He was convicted, and then the Third Circuit reversed on the grounds that the statute's unconstitutional, that the speech is fully protected under the First Amendment. There is no exception, and that whatever interests the government has are not sufficiently weighty to justify censoring speech. They should go after the underlying conduct, which obviously can be criminalized and is illegal everywhere. And so when the case gets to the Supreme Court and cert is first granted, I think most sort of free speech advocates weren't too alarmed about this and weren't probably going to go out and fall on their swords to protect depictions of animal cruelty. But some of that attitude changed when the government's merits brief was actually filed in the case, and it took quite a remarkable series of positions about the First Amendment. First of all, in arguing for the creation of a whole new exception, it advocated a very loosey-goosey balancing test derived from the Chaplinsky case in 1949, and argued that the interests that could be weighed in that balance were things like the effect of the speech on the morals of the people who were viewing the movies and the sort of debasing of the culture, the kind of thing that you would ordinarily think the First Amendment precludes the government from trying to regulate speech to effect, which is the effect on the recipients and the effect on the overall culture. The government's brief also made a remarkable argument that even if this is fully protected speech, the statute should still be left in place, and we should have criminal prosecutions in which each time there's a prosecution, the courts will decide whether or not there's a sufficiently compelling interest in prosecuting this particular individual to satisfy strict scrutiny on those particular facts, an approach that has never been adopted in any context in the past in a situation where there was a content-based regulation of speech, fully protected speech, just because obviously it's going to be extremely difficult for anybody to decide what's lawful to say if you have to anticipate the application of constitutional strict scrutiny by the court when you get there and try to figure out whether or not that would or wouldn't allow you to violate the statute in a given situation. So we have a very interesting case where the government took a pretty aggressive posture. I think, as Tommy was saying before we started, the reply brief kind of took some of it back, or at least changed the tone and focused more on the fact that this is depictions of really bad conduct. It's just like child pornography. We should be able to ban movies that show these bad things happening because animals are getting hurt when they're making these movies. And the court might ultimately say that, and if they rule on that ground, it'll at least be a very narrow ruling and probably leave the rest of the First Amendment pretty much in place. It's a little hard to predict because the court almost has to take a case like this where a federal statute was held unconstitutional and where the United States is asking for a grant of cert. I mean, it would have been quite surprising if they hadn't granted cert, so it doesn't tell you too much. Switching gears to the Establishment Clause of the First Amendment, we have the Salazar versus Buono case involving a cross in a very isolated hillside in the Mojave National Preserve in Southern California that was erected back in the 30s as a memorial to World War I soldiers by private citizens and has been sort of kept there over the years or replaced with a series of other crosses over the years, precipitating a controversy only fairly recently when somebody asked the Park Service whether they could put a Buddhist shrine there And the Park Service responded by saying, we're going to get rid of all of this stuff, leading Congress to get all exercised because this was initially a memorial to World War I dead, and Congress passing a series of laws trying to force the Park Service to keep it, which in turn leads to a constitutional challenge in the federal court in California, which held that the existence of this cross on public land, a symbol of a particular religion, even with a history of it being a memorial to war dead, was a violation of the Establishment Clause. As the case is then going up to the Ninth Circuit, Congress passes yet another law in which they authorize a swap of land under which the particular little hillside on which this cross stands would then be privately owned by the VFW chapter or one of the members of the VFW chapter, and the government would get a piece of land from that individual. Hopefully, they thought, solving the Establishment Clause problem. The Ninth Circuit went ahead and affirmed the original injunction. The government went ahead and tried to go through with this land swap. The district court then enforced an additional injunction against the land swap, saying it doesn't solve the Establishment Clause problem. It's a violation of my original order. And the Ninth Circuit affirmed again. So that's a long, complicated story. But as it comes to the Supreme Court, which granted cert, there's two issues. One, whether the particular individual who challenged this cross has standing to challenge it. And the issue there is that he is a Catholic who doesn't object to looking at the cross in principle, he says, but objected to seeing it on public land in a situation where no other religion was being allowed access. And the government is saying, well, that's just kind of abstract Establishment Clause standing. It doesn't really work for you to say, I think I'm injured because I see the government violating the Establishment Clause. It doesn't affect me personally. So they're essentially saying, for example, that a prayer in school case, it would have to be somebody other than a member of the majority religion whose prayer is being said that would challenge a Jewish person, for example, or something like that, not just somebody who objects in principle to violations of the Establishment Clause. Then there is the second question of whether the land swap, in fact, did solve the constitutional problem, which is, who knows how the court's going to answer these things. It remains to this day a national memorial to World War I dead, even though it's now on private land. So that's one of the various things that Congress did in the process of trying to keep this place, was name it a national memorial. So in some ways you could say it doesn't really matter who owns title to the land. It's still something in which Congress is making a statement affirmatively about a particular religion, using the symbol of one religion as a way to honor war dead, which, if it's a violation of the Establishment Clause, it's a violation of the Establishment Clause, whether or not title was shifted on the land. I'm afraid that's another case where I have really very little idea what the court is going to do, except I think you'd have to assume they didn't take this case just to affirm the Ninth Circuit, which isn't their habit anyway, usually. So I wouldn't be surprised if we got a very aggressive ruling on Establishment Clause standing, which would cut back on the ability of people to bring some of these cases. On the other hand, that may not be where they go, and they might just decide, look, this thing is not really a religious expression. It was erected as a memorial to war dead, and it's on private land, and crosses sort of are all over the place anyway. Maybe they'll just find a way to view this as the secular Ten Commandments instead of the religious Ten Commandments. The Establishment Clause is such a difficult to predict area because the court just kind of goes like this most of the time, tries to figure out what it's doing. So those are the two First Amendment cases that Tommy asked me to talk about.
Terrific. Stevens is a criminal case, and so maybe we can continue with the theme of bringing in the criminal docket because there's an awful lot going on there. Pam Harris, cases about honest services fraud, Miranda, a variety of things.
I'll start with Miranda. The court has two Miranda cases on its docket, and that's sort of necessarily a big deal because the court hasn't taken a big Miranda case in about 5 years, so this is a little bit new. One of them, Florida versus Powell, is about the precise contents of the Miranda warning, and in particular, whether the police have to tell the suspect, your right to counsel means you have a right to have a lawyer present during questioning, not just a right to consult before and after. The other case, Maryland versus Schatzer, is about what happens if the suspect, when he gets the warnings, and this is quite unusual, actually invokes his right to counsel and says, I don't want to talk to you without a lawyer. Under a case called Edwards, the basic answer is the police are out of luck. They can't try again. They can't go back to him, read him his rights again, and see if he wants to waive this time. And the question in Schatzer is whether that bar on police reinterrogation, whether it expires at some point in time. And it was 2.5 years between police encounters. Schatzer, which is a long time. or whether some changed circumstances might bring the Edwards bar to an end. All right, also difficult to predict Miranda cases, but my guess is both of these cases will be decided in the state's favor. I'm sorry, I'm getting some hand gestures.
Yeah, Michael, will you take this off, and we'll give that to Pam here. It's not the mic.
Is it something I said?
I was going to say, that's right. Yeah, exactly.
Okay, good. My guess is that both of these cases are going to be decided in the state's favor,
Thank you.
but that both will be decided on relatively narrow grounds. And that's important because when the court granted in Schatzer, the thinking was that they might be prepared to overrule Edwards altogether, which would be a big deal. And the state's opening brief sort of reflects this, and it does ask somewhat tentatively, sort of says, look, if you don't buy our narrow arguments, you ought to think about getting rid of Edwards altogether. I don't think that's going to happen, and that's ironically, sort of, at the end of last term, the court did overrule outright, it's a little technical, but it overruled outright the Sixth Amendment right to counsel counterpart to Edwards, a case called Michigan versus Jackson. It's Edwards in the Sixth Amendment context. The court overruled it, but they said the reason we can do this is because you guys, the defendants, still have Edwards out there. Edwards gives you all the protection you need. And it spoke about Edwards as though it wasn't going anywhere anytime soon. It was still going to be the baseline protection. And after that, you actually see the briefing in Schatzer change a little bit, and no one's talking about overruling Edwards anymore. I think it's pretty much in place, at least for now. So my guess is that in Schatzer, as well as the Powell case, you get narrow rulings, which means almost inevitably arguments directed at Justice Kennedy as a potential swing vote. Maybe Justice Breyer also, but I think very much Justice Kennedy. And what I'm looking for there, and what I think will be interesting, is what role good faith plays in these cases, how much emphasis we see on the fact that the officers in both of these cases appear to be acting in good faith. There didn't seem to be an intentional effort to undermine Miranda, get around Miranda by badgering the suspect until he would talk. That has been very important to Justice Kennedy in the past, and I wouldn't be surprised to see it resurface here. That said, even a narrow holding for the state in this Schatzer case is a pretty significant development. And that's because Edwards has stood for a long time now as a kind of high watermark in terms of court-developed rules that protect the Miranda right. One of the most Miranda protective rules the court has ever developed. It has enforced it very consistently, even as the court grew more conservative. The court has refused to make exceptions to Edwards. It's insisted on a very broad, bright-line application for that rule. If the court makes an exception here, and again, I think the facts are pretty good for the state, but if the court makes an exception here, that's a significant departure. And for people wondering how Miranda will fare in the new Roberts court, it would not be a good sign. Last point, these cases are, as I said, the first real cut at Miranda for Chief Justice Roberts and Justice Alito. They were not on the court when the court reaffirmed Miranda in the Dickerson case, and we don't know how they would have voted in that case, whether they are reconciled now to Miranda in the way that Chief Justice Rehnquist turned out to be. What we do know about both of those justices is that their service in the Reagan Department of Justice, which was very much opposed to both Miranda and the exclusionary rule, viewed those cases sort of together as Warren Court excesses. We know that their service in that Department of Justice has stayed with them when they consider exclusionary rule cases. And I think the question is whether it will have the same influence on them when they think about Miranda cases, and whether you'll see the same kind of fundamental discomfort with Miranda as you see in the exclusionary rule context. And for me, that's what I'm looking at in these cases, whether something that either of those justices writes kind of tips their hand in terms of how they're thinking about Miranda generally. All right, the honest services cases, I'm just going to say a few words about those because they are so important in a practical sense. The court has two honest services cases in front of it, Black versus United States and Weirauch versus United States. Very important for white-collar prosecutions and especially public corruption prosecutions, which often rely on the honest services provision of the federal wire fraud and mail fraud statute. It criminalizes the denial of what is called, in the statutory language, the intangible right to honest services. And the idea is that if you violate some rule, engage in some shady dealings, you have deprived the public of the benefit of your honest services if you're a public official, or you've deprived your employer of your honest services if you're a private employee. No real dispute that this is very, very open-ended language. So that, for instance, if you use your computer to buy shoes when you're at work, maybe you've deprived your employer of your honest services. If you call in sick to go to a baseball game, congratulations, you're now a federal criminal. And that particular example, the baseball game, that comes from Justice Scalia. I stole it without telling him. That comes from Justice Scalia in a dissent from denial of cert last term, where he wrote a separate opinion saying, listen, we really have to take up this statute. I'm very concerned about the breadth, the vagueness, and it's time for the court to step in. And sure enough, the court does grant cert after that in 2 cases, Black and Wyrick, each of which presents its own potential limit on the scope of this statute. All right, I think chances are pretty good that with Scalia leading the charge that the court is going to do something to narrow the scope of the statute. And the question really is how much? How much are they going to cut back on it? I think there's the potential in these cases for some interesting coalitions among justices, because the statute doesn't just raise criminal law problems, a serious problem that people are being prosecuted without really being on notice of what's permitted and what's prohibited. It also raises separation of powers problems. There are lower courts saying right out there in their opinions, well, Congress has left to us the task of filling in the content of this statute. It's vague on its face, so we have to make up some rules. That's a problem for separation of powers. Federal criminal law is supposed to be made by Congress, not the courts. It also raises some very interesting federalism questions. And I think when the court granted cert in Wyrick, which is the second case, it probably did it with an eye toward the federalism dimensions of the case, and maybe it was a strategic grant, knowing that you might bring in some justices in that case who aren't always very pro-defendant in their outlook. Wyrick involves an Alaska state representative who has a conflict of interest that does not appear to be illegal under Alaska law. But then you get these federal officials stepping in and saying effectively, we don't care what Alaska thinks. We in the federal government don't think that that's the right way for Alaska legislators to do their job. And that really does raise very sharply some important federalism questions that might bring in some justices who might not otherwise be on board with narrowing the scope of this statute. All right, I'm just going to talk very quickly. Do I have 2 more minutes? One last case in the Sixth Amendment context, the Confrontation Clause. We have now the follow-on to Melendez-Diaz, which was the Confrontation Clause case from the end of last term. Court holds that lab reports are testimonial under the Confrontation Clause, means that they can't be introduced at trial unless the defendant has a right to cross-examine the analyst who prepared them. The question in this follow-on case, Briscoe versus Virginia, is whether it's enough that the defendant can call the lab analyst as his own witness, or whether the state has the responsibility for making sure the analyst is there and ready to be cross-examined. Here's what's odd about this case. On its face, Melendez-Diaz already answers that question, because the court found a Confrontation Clause violation in that case, even though the defendant had the right to subpoena the analyst. Seems like the question is answered. Seems like what the court should have done in Briscoe is sent the case back down to the Virginia Supreme Court to reconsider in light of what it just said in Melendez-Diaz. It doesn't do that. 3 days later, after it hands down Melendez-Diaz, it grants in Briscoe. And I think the question is why? What's going to change now so that hearing this case isn't just hearing Melendez-Diaz all over again? The biggest and most obvious change is a new justice, Justice Sotomayor. And I think all eyes are going to be on her in this case. Melendez-Diaz is 5-4, and Justice Souter is in the majority. The dissent, a very pragmatic dissent, not particularly ideological, very practical concerns. This is going to slow the criminal justice system to a halt. We really can't do this. We don't have enough analyst time to waste it with people going to court in these silly little cases. And the question is whether Justice Sotomayor, with her years as a prosecutor, is going to be more receptive to that kind of pragmatic argument than Justice Souter was, and whether she might flip the court in Briscoe. I don't think so. My best hunch, and it's just a guess, is probably not, because I don't think that the dissent's concerns from Melendez-Diaz have really played out over time. Right after the opinion came down, there was a lot of confusion. Analysts didn't know what to do. The prosecutors were sort of caught unawares, and there was some, call it like a startup cost. I think by now the system is pretty well acclimated to Melendez-Diaz. It turns out a lot of times defendants are prepared to waive their right to cross-examine. You don't really have to have the analyst there in every case. Things are basically running smoothly again. But I think that will be a big part of the argument when we get to Briscoe. How has Melendez-Diaz played out in practice?
Fantastic. So, Michael, Pam mentioned separation of powers, and we have a separation of powers case this term called Free Enterprise Fund that you were in at the very, very beginning, involving the agency that sets the rules for Sarbanes-Oxley, where you find yourself arguing for more power for President Obama. Thank you. And he doesn't want it. It's very strange. And so could you introduce that case and give us your thoughts? And maybe Doug might, it's possible, disagree?
Yeah, my job today is to get the American Constitutional Society to side with individuals against the government in enhancing governmental rights. I'm kind of serious. This term you'll see I'm advocating Fifth Amendment takings against the government, Second Amendment gun rights against the government. We've already heard my ringing defense of the First Amendment. And it will be a sort of an interesting test of whether liberals believe, as they claim to, that they're going to engage in expansive interpretations of the Bill of Rights versus the government, or whether or not anything the Democratic Party happens to believe at the time they've enshrined as their guidepost for constitutional
jurisprudence.
Because
you're out there for the Fourth, Fifth, and Sixth Amendments too.
Absolutely.
Okay.
That's all by way of preface to saying we tend to focus on the Bill of Rights as the guarantors of individual liberty. The real protection is the structural protection as Madison understood and the framers understood in terms of separation of powers. And this is all fifth grade civics class stuff, and I'll go through it real quickly. But they separated the legislative and the executive and the judicial for a fairly obvious reason. If you combine the legislative and executive power, the ability to make laws and enforce the laws, that's what King George did. And that is the ultimate definition of tyranny. So they wanted to make sure that Congress wasn't able to influence how their laws were influenced. And much more important, particularly I would think for this audience, it's all about accountability. It's all about making sure that the people are sovereign and the government is responsive to them rather than vice versa. So if you're voting for Barack Obama because you want to see the abuses of the government, the executive branch that existed for 8 years stopped, he can change in a way you can believe in. Now, that can't happen. That can't happen if you have sort of a permanent bureaucracy that's not beholden to the president. Because if the president's not in charge of enforcing the law, and the people only have power over the president, then the people can't change abuses or policies that they view as ill-advised. So if Barack Obama ran, it's not really dissimilar from what really happened, that the enforcement of corporate accounting and all this was grotesquely bad. There's an agency out there called the PCAOB that was created by Sarbanes-Oxley. And it was created to ensure that corporate auditing was done in a serious way so we wouldn't have more of these Enron-type scandals. And so it serves a very important purpose. It's got the unique ability to actually tax these companies and fund itself. It doesn't go to Congress for money. It funds itself. And it was designated in the statute as a private corporation. So it's exercising extraordinarily powerful government, potentially tyrannical power, and what kind of control does the president have over it? None. Zero, literally. He doesn't appoint the board members. He can't fire them under any circumstances. He can't, as I said, review their budget because they tax themselves. And he can't review their work product. So we now have a situation where a governmental entity exercising a fundamental power over the citizens is totally divorced from the president, and therefore totally divorced from the populace's ability to change the direction. So if Barack came in and said, I really want to get rid of those morons at the PCAOB, there's not a thing he could do about it. They're there, he can't fire them, and he can't appoint the new one. So now we have the separation of powers. And again, liberals are generally very insistent that the legislature shouldn't interfere with the judiciary. We want to maintain an independent judiciary. We don't want the executive interfering with the legislative power in the war-making area and that kind of thing. And so this question is just whether Congress can divorce the executive power from the executive in a way that makes them completely unresponsive to the president. And the defense of this agency, which is literally unprecedented in American history. We have all, I think, become accustomed to what's called the fourth branch of government, the so-called independent agencies, the SEC, the FCC, the FTC, these creations of Humphrey's executor, which are nominally more independent from the president than the traditional cabinet kind of agencies like the Justice Department, et cetera. But with respect to all of those agencies, the president gets to appoint them. He gets to remove them, admittedly under limited circumstances, but he can remove them. And he gets to appoint the chairmen, who generally are very dominant at these agencies, at his pleasure. As we just saw, for example, with Bernanke, he gets to decide who the new chairman is going to be. So the president does have a lot of power, indirect although it is, over these so-called independent agencies. What the PCAOB is a fifth branch, where they don't allow the president to have any interaction with this PCAOB, but they say that the SEC, a fourth branch agency, will review some of its regulations and all of that. And bizarrely, the Justice Department is going to come in and say, no, strip the president of all his executive power. That's fine with us because the SEC has this sort of nominal control over this fifth branch agency. I'm making two not terribly sophisticated responsive arguments. One is that Article 2 of the Constitution doesn't mention the SEC, so it doesn't really matter if the SEC can control this corporation. And number two, if the president can't tell the SEC what to do because they're independent, then the fact that the SEC nominally controls the PCAOB is completely irrelevant. So the court below said that the dissent below said that this was the most important separation of powers case in 20 years, and it obviously is. The last case that you probably remember was Morrison v. Olson that dealt with the independent counsel. And generally that was perceived, I think, as the notion that, look, the president has an inherent conflict of interest looking at his political cronies and bringing criminal enforcement charges against them. So the court sort of very pragmatically said you can slice that little bit of executive power away and give it to this independent counsel, and that doesn't disrupt the constitutional scheme. But the other point I'd like to make about this case is Congress gave absolutely no reason for creating this fifth branch agency. The proposal was, look, give this power to the SEC, a traditional independent agency, or design it like a traditional independent agency. And Congress has absolutely no reason to divorce this executive power and create yet another buffer between the executive and the executive power. My point being, it's not as if this is like a compelling interest or some unusual circumstance like there was in Morrison v. Olson. So if the court accepts this notion, there's absolutely no constitutional reason that Congress couldn't pass a law tomorrow doing it to the Defense Department, the Justice Department, the State Department, and all of these others, putting the power to do all those inherent executive powers in these independent agencies that are divorced from the president, overseen by these bipartisan commissions. So to wrap up, in 4 years when the country returns to its senses, and we put back a Republican in the White House, Congress would still have the ability to ensure that change I can believe in is never manifested by the new president changing the misguided policies that the polity now believes in. And I think whichever side of the debate you're on, you can't really believe that it makes a lot of sense to empower a permanent bureaucracy that is utterly immune from the democratic process and the kind of accountability that this administration has been endorsing.
Sure.
I make it a point in life never to agree with Mike Carvin about anything, but actually this is an exception, I have to say. I actually agree with much of what he said about how really extreme this particular agency is, sort of doubly insulated from presidential power, exercising its own right to put out regulations and raising its own tax revenues and paying itself. Each of these guys, I guess, earned $650,000, which is like triple what the president's paid. And so, I mean, I think that unless the court's going to can figure out a way to really characterize this as not part of the government, that this is really industry self-regulation or something, which isn't going to be easy, I think they're going to say this is a violation of separation of powers. But the reason I wanted to jump in, Tommy, is I think if you were trying to figure out the perfect vehicle to begin a movement of the law back in the direction of what a lot of in the conservative movement want to do, of unitary executive and getting rid of the SEC after you've gotten rid of the PCAOB, this was a godsend case. I mean, it was almost like the Republicans in Congress must have passed it on purpose to give you this case, Mike, because, I mean, it's going to give Justice Scalia the right to have his dissent in Morrison v. Olson basically become the law of the land, and start talking about how you can't, it's very problematic in general to have officials in the executive branch that can only be removed for cause, which is what the SEC, the FDA, the FTC, the FCC are. And you know, there is clearly a group of people out there who would like to go well beyond the PCAOB and start establishing that there isn't such a thing as a fourth branch. And so what will be, I think, most interesting to see how broadly written or narrowly written the majority opinion is, at least if I'm right about predicting that Mike is going to have a smashing victory in this case. Do you want to disagree with me now,
No,
Doug?
I think we're all in agreement to a certain extent, but let me go back to fifth grade civics, because Mike very well explains that there's a proposition of separation of powers, but there's also a proposition of checks and balances. And the entire unitary executive is built on this idea that there's sweeping language in Article 2 of the Constitution, which there is, but there's also sweeping language in Article 1, which gives Congress powers that seem to overlap into executive powers. And so the question is not whether there's, you know, it's two very basic civics propositions that are coming up against one another in these theories, and that's why Justice Scalia's dissent in Morrison was a single justice dissent against the majority opinion written by my best friend here today, Chief Justice Rehnquist, who I think pretty well eviscerates the much of the unitary executive theory, and I think that's. But I will echo what Paul just said, which is that this I think Mike has brilliantly made the case that this peekaboo board is beyond what the court has upheld before. And I think it is entirely possible that there will be 5 votes on the court to say this is or maybe more than that this is a bridge too far. The question is how broadly this court accepts the theory of unitary executive articulated, agreed to by John Roberts and Sam Alito when they were in the Reagan administration, and then written into the dissent of Justice Scalia. How much of that gets in a majority opinion? On that question, I think the opinion last term, the FCC versus Fox Network opinion, where where Justice Scalia writes a majority opinion, includes a little section that Justice Stevens describes as the unitary executive section, and that's the one point that Justice Kennedy doesn't join in the entire opinion. So it's going to be a classic battle in terms of the court's dynamics about how that plays out, I think, and I think it's going to be a fight for Justice Kennedy's vote on that.
Let's come back to criminal law. Not only do we have substantive criminal law questions, but we have criminal law issues that overlap with civil rights questions, the ability to bring claims against prosecutors, questions about what we do in juvenile sentencing, and other issues. So, Lisa?
Great. Thanks, Tom. Well, let's start in Troy, Alabama. Always a good place to start. Troy, Alabama is a small town in southeast Alabama. And it's the place in Alabama that has the highest number of capital convictions, capital charges and convictions per capita in Alabama, and that is really saying something. We have a case out of that area, Hollywood versus Allen. Mr. Wood was arrested, charged with the death of his former girlfriend. And literally around the same month that he was arrested, there was a very young man just out of law school who was getting sworn in as a new lawyer down the street. And this young man, fine young man, Mr. Trotter, obviously had never had a death penalty case, had never had a criminal case, had never been before a jury. He's appointed to represent Mr. Woods. Now, 2 other attorneys, more experienced, are also appointed to represent Mr. Woods. So that's kosher. But then on the eve of trial, Mr. Trotter, the new attorney, is told, in fact, you're in charge of the entire penalty phase. So if the jury should come back with a finding of guilt, you're going to be the one who's in charge of of pleading with this guilty and making an argument that Mr. Woods should live rather than be killed. So Mr. Trotter, young attorney, obviously freaked out at this point. Not a position you want to be in. He'd realized 5 months earlier there had been a psychologist who'd come in and had done a sort of standard determination, is Mr. Woods competent to stand trial? And this psychologist had found, yes, competent to stand trial, not surprisingly. That's a very low standard. But then he had written, however, Mr. Woods has a very compromised, very compromised mental state. Now, if you're an experienced death penalty lawyer, or if you're just an experienced lawyer, you know immediately, you see that sort of phrase, you will go out and investigate this. And this is this is the most persuasive mitigation evidence that you can bring in front of a jury or a judge, is that this person who you have found guilty is, in fact, someone who's operating with a very compromised mental state. You would go talk to special ed teachers. You would go get records. You would go ask for another psychological exam. Mr. Trotter, brand new attorney, didn't do any of this. And so found guilty, sentenced to death. Now, the state court in post-conviction proceedings makes a determination that the reason the defense team did not bring in any mitigating evidence of this sort is because they had made a strategic decision not to. Right? Now, in this ineffective assistance of counsel claim, if you had failed to bring up any mitigation because you had failed to investigate, that's a problem. That's ineffective assistance. If you had failed to bring it up because of some strategic decision, then it's a strategic decision. There's no ineffective claim that's going to carry the day there. Well, the state court, how did they make this analysis to determine that the fact that there was no investigation and that there was no presentation was somehow a strategic decision? They used a very time-honored Alabama court judicial analysis, a three-part analysis called Control A, Control C, Control V, which is to take the proposed order from the state prosecutor and to cut and paste the entire thing and to adopt it as their own order. So this three-part analysis they did, and this is what was the finding of the state court. Now, if you want, the best thing to read about this case is actually the amicus brief from the National Association of Criminal Defense Lawyers, which describes how prevalent this is, how prevalent this sort of cut and paste judicial process is in Alabama. And what they bring to the attention of the court is in case after case, what you have is instances like all the topographical errors of the proposed order makes its way into the state court order. There are cases where more than once the word proposed in front of order makes it in, and the order is called a proposed order. And then my favorite is giving you a sense that perhaps the judge did not closely examine the proposed order. The judge's own name is spelled wrong. So it's gotten to be such an embarrassment, right, that these state prosecutors actually now put a cover sheet when they put in their proposed order. And in this cover sheet, they say it's a Dear Judge letter. It's standard. And it says, Dear Judge, should you decide to adopt our proposed order verbatim, as we hope you do, we would really ask that you add this language, that you add the language, the court adopted the proposed order only after considering all the evidence and the arguments of both parties. So now state court orders come out with the cut and paste order verbatim, and then the cut and paste, the court adopted the proposed order only after considering all the evidence and the arguments of both parties. The question in Hollywood is this. It's a question of what kind of deference does a federal court reviewing this federal constitutional question, what deference is due this kind of judicial, I'm looking for a word with more than 4 letters, nonsense. Okay? There's no question, EDPA, the Anti-Terrorism and Effective Death Penalty Act of 1996. There's no question that AEDPA has constrained the federal court's review of a state court's findings. The conflict in the circuit courts is just how tightly they have constrained that review. There's a split among the circuits, and in my very objective opinion, the 11th Circuit, which is where we practice and where this case comes out of, the 11th Circuit has by far the most restrictive reading. They've managed to take two different parts of AEDPA, sort of mush them together, and come up with a brand new standard that's almost impossible to meet, which is saying when a federal court is trying to determine whether there's been a federal constitutional violation, when they're looking at a state court order, the federal court has to give a presumption that the state court is correct, and then you have to point to particularized, clear and convincing evidence to say which parts of it is incorrect. There's a split on that. It may be a good thing that the court took this case. I'm hopeful, but it'll be very interesting to see what the court says about that.
Okay, so we have a couple more minutes if we can just maybe summarize the other cases you wanted to focus on.
The other thing to take a look at is, Sullivan versus Florida is coming up. That's the juvenile life without parole case. Joe Sullivan, 13 years old when he was arrested for sexual battery, a non-homicide case, one-day trial, sentenced to prison for the rest of his life without any possibility of parole, 13 years old. The question here is simply, is this court going to extend Roper? And Roper, of course, where the court held in 2005, it's unconstitutional to impose the death penalty on children under 18. And that's one where, if you read all of the reasoning that Kennedy had for why you cannot execute a child under 18, the same reasoning applies to life without parole. Okay. And just one other case, if I can just touch on, it's not a criminal case, but it's about the criminal justice system. It's Pottawatomie County, and my apologies to Pottawatomie County if I pronounce that wrong, but Pottawatomie County, Iowa, is a case where prosecutors were caught acting very, very badly. It's not a case where prosecutors were caught acting badly, where they, for example, are hiding evidence. They did that. But here they're acting very badly. They actually fabricated the evidence. The question there is a question of how much immunity do we give a prosecutor? It's one of these things where common sense would tell you where, in a case like this, where a prosecutor was so intent on getting a conviction of one particular person that after 2 months of investigation led to no arrest, he jumped into the police function, started investigating alongside the police, fabricated evidence, coerced false evidence, and then did a whole range of bad sort of prosecutorial acts that landed 2 young, innocent men in prison for 25 years. Common sense tells you that when those 2 men come out of prison, should they want to recover damages, they should be able to sue this prosecutor. The prosecutors in this case are insisting that they have absolute immunity. And there's a difference here between qualified immunity, absolute immunity. But I hope you take a look at that case. There's a certain cringe factor to it. You feel very bad for the attorney who's trying to defend the actions of this prosecutor. But it's one where if it goes the way the prosecutors would like, the prosecutors would like it to go, it would just give blanket absolute immunity to anything that a prosecutor does, whether it's in his role as a prosecutor or in its role not as a prosecutor but sort of acting as a police investigator. Very interesting that they took that case, and we'll see what happens with that one.
Thanks very much. Can we switch gears now to the business docket? Yeah.
Yes, I think I've drawn what is apparently the short straw in this panel, in this group, but I'll try to make it interesting. I think there actually are a number of interesting cases on the business docket this year, and I'm going to kick off with my favorite one. For me, the American Needle case is the Reese's peanut butter of cases because it involves 2 of my favorite things, antitrust law and the NFL. So I should note as a caveat that I worked on the government's invitation brief when I was in the Solicitor General's office, but the views I'm expressing here are my own. The case involves the NFL's intellectual property. The teams are all separately owned, individually owned teams, but they've pulled together their intellectual property in something called NFLP, NFL Properties, and allowed that entity to market their logos. And more recently, that entity has decided to allow only Reebok to make products with their logos. And American Needle used to make NFL licensed products and wants to, and so they've sued the NFL complaining about that arrangement. And the question in the case is what is a single entity for Section 1 of the Sherman Act? Section 1 of the Sherman Act, it involves conspiring, two companies conspiring with one another, and the court held in Copperweld that if you're a single economic entity, you can't conspire. Copperweld involved a wholly owned subsidiary of a corporation, and the court held that couldn't be conspiracy. And the Seventh Circuit here, in ruling for the NFL, held that the NFL is a single economic entity because it takes, two to tango. You can't have a football game unless there's more than one football team. So they're producing a product, football games, and then the intellectual property agreement is just a way of promoting that joint product. And so therefore they can't be liable under Section 1 of the Sherman Act. And the court has granted review. And so what's the importance of this case outside, unless you want to buy a non-Reebok hat of your favorite team? It might affect your ability to do that. But it also, now that the court's granted, and one of the reasons the Solicitor General's office recommended the court that it not grant cert is because it was in the sports league context. But now that the court has granted it, the reasoning of any opinion, even if it attempts to be limited to the sports league context, could apply to any type of joint venture, including, and there are all kinds of contractual arrangements whenever a company might enter into some type of contractual arrangement with someone who's otherwise or sometimes their competitor. For example, if Company A were to agree with Company B that Company B is going to market its product over its network, are they a single entity? Could they agree to price terms on that? So the case could end up having implications to the business community far beyond professional sports teams. The second case I wanted to talk about is it's an extremely important patent case, and one of the reporters here told me that several years ago someone told him this was the most important patent case ever, and now people are telling him this is the most important patent case ever, and he wasn't going to believe that anymore. The court has taken a string of patent cases, and I think one of the interesting cases about this is called Bilski, and it is a fundamental question of patent law. What is an eligible process? The patent laws allow for the patenting of a process. At issue in Bilski is what is called a business method process. Specifically, it involves a theory of hedge fund risk management. But I think this case also poses the question of, can the Federal Circuit ever catch a break? Because the Federal Circuit, several years ago, the court took this question in a case called LabCorp and then dismissed the case as improvidently granted. And 4 justices dissented from the dismissal, strongly suggesting that the Federal Circuit should reconsider its test and follow Supreme Court precedent. So in Bilski, the Federal Circuit did just that. It took this case en banc, reconsidered its precedent, threw out the test that had been questioned in the dissent in LabCorp, and followed the Supreme Court's precedent. And nevertheless, the court has granted. I also should issue. I worked on the government's opposition to Bilski to the cert petition when I was in the government. So these are still my views. But nevertheless, the court's taken cert. So, what's the Federal Circuit to do? And it's an interesting grant in the sense that only one judge in the Federal Circuit of the whole en banc court thought that Mr. Bilski's patent was eligible to be patented. And so it's an interesting case to take a question about delineating what should be the test for eligibility when only one judge on the Federal Circuit. So in other words, it's not a case where the Federal Circuit judges thought this was close to the line. Only one of the judges thought that it was eligible to be patented. So it'll be interesting to see what the court does with it. Although this is a pure business method patent, The question is, because the word in the statute being interpreted will be process, there's great interest in the world as to how broad, what other things will be affected, what other types of processes will be affected. And there are 44 amicus briefs on the top side alone. And another interesting point of note, I see Tommy's holding his watch. Another interesting point of note about this is that on September 16th, the Federal Circuit issued a decision applying the Bilski test to a medical test, so outside the business method context, but to a medical process that's much more similar to the process that would issue at LabCorp. And the Federal Circuit, applying its new machine or transformation test, which is the test that issued in Bilski, held that that medical process was eligible to be patented. So since the cert grant, there's been more refinement in the Federal Circuit as to what is eligible in their view and what's not eligible, and it will be interesting to see what the court does with that. And then do I have time for one more? One last case I was going to touch on is a case called Merck. And Merck, I think, can be seen as possibly part of a trend where the court's been taking cases, cutting back on the plaintiff's bar. Merck involves when the statute of limitations begins to run in a private action for securities fraud. And again, as a way of disclaimer, we filed a brief on behalf of the Chamber of Commerce in that case. But the circuits are divided, and they've essentially adopted 3 different tests. At what point does the plaintiff know enough that it should file? And in the facts of Merck, it involves the drug Vioxx, an arthritis drug. The FDA had come out with a warning letter and warned Merck that it was not marketing the drug properly, that it was not adequately disclosing the risks of cardiovascular effects of the drug. More than 2 years, and that letter was highly publicized in the press, more than 2 years before this action was filed. But nevertheless, the Court of Appeals held that this action was not untimely, and that in order for the statute of limitations to run, the plaintiff needed to have specific evidence of intent before the statute of limitations would begin to run. And it'll be interesting to see what the court does with these. There are 3 possible tests that the statute should begin to run as soon as the plaintiff is on inquiry notice, as soon as the plaintiffs have facts sufficient to put it on notice that there might be a fraud, or whether the plaintiff should be allowed some reasonable time to investigate, or whether the plaintiff should be allowed some hypothetical reasonable time to investigate. And what I think one of the significant things about this case is that it's likely the loosey-goosey statute of limitations that exists in some circuits likely allows the filing of weak claims. That when claims are fairly strong, they're filed fairly swiftly by the plaintiff's bar. And that when claims are dragged out and not filed quickly, it could be a sign that the plaintiff's bar doesn't think those claims are really strong. Yet such claims still lead to strike suits and forced settlements. So, but it'll be interesting to see what happens.
Thank you. So I want to make sure that we have time to talk about guns, but maybe just talk about them. No one should pull out a gun. Not to look directly at you, Michael. Coincidence. Nunchucks. But I do want, if I could ask you as a favor, there is a takings case. And I wonder if you could we could describe the takings case and the unique takings issue that's presented there, and then we'll turn to the gun cert petitions.
Sure. It's called Stop the Beach Replenishment. It's very much in the classic takings mode. It's not involved contracts or income redistribution. I mean, it's real land, real property. And it gets very complicated. But the essential point is this. If you have a beach house, under traditional Florida law, this case out of Florida, you owned all the sand up to the high water mark, basically where high tide was. So you own the land up to the water. Now, if you know about beaches, these days especially, sometimes it's going in. You're getting less and less beach, so you're losing land, and that's your tough luck. And on the other hand, if the beach goes out, you get extra land, but it's all your land, and it goes to the water. So they tried these beach replenishment operations in Florida, and I think the facts are roughly that these landowners had about 200 feet of beach in front of them, and then after the replenishment, they had about 275 feet. So they said under traditional Florida law, we get the extra 75 feet of land, that's ours. Florida said, no, that's ours, and we're going to provide access to other people for various reasons. And if it is the property owner's land, then it's a classic takings under Nolan and Dolan and these other cases where the government has imposed all these kinds of restrictions on private property. The interesting issue in the case is, and I don't mean to be obsessing about Bush v. Gore or the Florida Supreme Court, the issue in the case is the Florida Supreme Court, some would say typically, changed Florida law to achieve a policy result they wanted. They said, no, pretend those other cases don't exist that say the beach owner owns the land up to the water. That was really never the law. You didn't really ever have that right. So some people are calling it a judicial takings case. I think it's a classic legislative takings case. The interesting issue in the case is Florida Supreme Court seems to have changed retroactively pre-existing property rights by reinterpreting the common law. And very much like Bush v. Gore, the normal rule, of course, is state courts get to decide state law and the federal judiciary won't second guess it. But like in the Elections Clause context in Bush v. Gore and in the property context under the Fifth Amendment, if you allow state courts to sort of say north is south, then you're allowing state courts to eviscerate, again, retroactively property rights that the landowner had and that he invested with the expectation of having as long as he had the property. So to me, the interesting question is will the court second-guess a state court's view of state law property rights, and what kind of standard will they use to rein in potential abuses by state courts in retroactively undoing property?
So do you see any relationship, the comfort with looking at state law in the Election Clause context, very important, the Takings Clause context? We have this sort of less important due process context in the Wood case from Alabama where the guy's going to be executed. Do you have any similar comfort with looking at what the state courts say there?
I don't know the particulars of this, but I think the court's been pretty clear about second-guessing abuses in the due process context, at least in the death penalty context. So listen, if the Takings Clause can get the kind of review that death penalty cases have been getting, I'm all for it.
Excellent.
I suspect it's going to be much more like a Chevron kind of look. Was it a reasonable interpretation of state law as opposed to, clearly unreasonable?
Guns.
Guns. One of our most fundamental rights, Second Amendment. You guys have probably heard about the Heller case. Obviously, that involved D.C., and obviously, therefore, it didn't directly implicate the question of whether or not this applied to states. And before I was sort of being sarcastic and saying this is a term that will test the hypocrisy or intellectual honesty of liberals, I really think this is a litmus test on whether or not there's a principled liberal position. By that I mean, as you undoubtedly know, every substantive provision of the Bill of Rights has been incorporated through the 14th Amendment against the states. So the states can't, even though First Amendment says Congress can't establish religion, we've even said states can't establish religion or deprive free speech or free exercise. So the question is, does the Second Amendment right also restrict states' ability? And it's come up in a case out of Illinois where Chicago and I think Oak Park essentially had gun bans, not very different than what the District of Columbia did. A more unusual case out of the Second Circuit, which I believe Judge Sotomayor was involved with, involving nunchucks, not the traditional idea of weaponry. And then there was also a case out of the Ninth Circuit. The Ninth said that, yes, the Second Amendment was incorporated against the states, but that was dissolved, and now it's being reheard en banc. The Second and Seventh said no. There were these old cases where the court had said that the Second Amendment doesn't apply to the states. The point is that those cases were decided before the modern incorporation doctrine, which came around, the 1940s and 1960s. I think reasonable people can disagree about whether or not lower courts, should apply the Second Amendment because there is this obvious ambiguity in Supreme Court precedent. My own instinct, I'd be interested in others' views, is the court will take the case even though there's technically not a split, because I just don't think they can allow this state of uncertainty to persist in the wake of Heller. We'll find out, I guess, next week. And then the issue will be whether or not the Second Amendment is sort of the redheaded stepchild of the Bill of Rights and is not going to be incorporated against the states, or whether it's going to be given the same dignity as we've given to the Fourth Amendment and the others. As you can probably tell, I don't think there's a really good argument for saying that the Second Amendment is any less worthy of respect or any less deeply rooted in our traditions, particularly because at the time of the 14th Amendment, as the contemporaneous legislative history makes clear, one of the rights that they were most concerned about when they adopted the 14th Amendment was ensuring that the freedmen, the newly freed slaves, were not deprived of the ability to defend themselves against the Klan and all these other folks and not have their weapons taken away from them. So I don't think there's a case in terms of precedent or a case in terms of the history of the Second and 14th Amendment to suggest that it wouldn't be incorporated. I'll mention one other very interesting point, I think, in the way these cases have been brought to the court's attention. As I say, this incorporation through the 14th Amendment doctrine is very well established. There's another part of the 14th Amendment which I think linguistically much more naturally applies to the Second Amendment and the other Bill of Rights, called the Privileges and Immunities Clause. But in a case in the late 19th century called the Slaughterhouse cases, the court essentially gutted the Privileges and Immunities Clause. And there's been an interesting confluence of both liberal and conservatives who want the court to take the case, not decided on the incorporation ground, but decided on the ground of privileges and immunities. And if they did go that way, which I don't know how to handicap whether they'll reach out for that, that could actually have a fairly serious impact not only on Second Amendment rights, but other rights that people would consider basic privileges and immunities of being a national citizen that the states couldn't infringe on.
Yeah. Mike did a great job of describing kind of a core issue there. I think actually, though, I view this case as much more of a test of the court's conservatives than the liberals. I think, well, first of all, to correct one thing, there is a very important part of the Bill of Rights, the Seventh Amendment jury trial right, which you could call as procedural or you could call as substantive, but it hasn't been incorporated either. So the trial lawyers are delighted to have a greater jury trial right recognized, and that hasn't been recognized yet. It's going to create a problem if they decide that everything is now incorporated about what to do about that. So that's it. And I don't think, I actually expect that there will be more than 5 votes on the court on the incorporation question. I don't think the liberals will be able to say everything else, every other substantive provision of the Bill of Rights is protected, but this is not. And so I think we will see incorporation. The question, and Mike teed it up at the end, that is fascinating, is what the court's conservatives do with the privileges or immunities argument, which is being raised by the parties, by the NRA, as well as prominently by Alan Gura, who's representing the McDonald plaintiffs in one of the cases. It's his lead argument. And the court is being presented with, I believe, absolutely overwhelming evidence in text and history that incorporation was supposed to happen, but was supposed to happen through the Privileges or Immunities Clause. And so this presents, and this is an argument that Justice Thomas on the court has already said he's willing to entertain. And so you already have this buy-in to a certain extent on the right about reconsidering Slaughterhouse and revivifying the Privileges or Immunities Clause, and that's exactly what the gun rights plaintiffs are doing here, backed by a brief that my organization filed on behalf of scholars ranging from Jack Balkin to Randy Burnett, who's a very conservative libertarian.
So can I just interrupt? Both of you all say that this would be a huge deal. Why? What would follow outside the gun context if privileges or immunities was revived?
Well, so it's the centerpiece in many ways of the 14th Amendment, so probably the most important amendment of our Constitution. In my view, the text, the central text of our progressive Constitution. the clause that was designed to give the freedmen rights after the Civil War. This is the second sentence. It's a core sentence.
Okay, it's right there in the middle, and it's
so-
really it's like an
so we
example,
have this-
like something.
Well,
I mean,
have
it's
this
right.
whole
It's
line-
right there.
Okay, we have this whole line of cases that have been the most controversial line of cases in all of constitutional law that has been decided by the Supreme Court under the doctrine of substantive due process. A line of cases that runs from Myers versus Nebraska through Roe v. Wade and through Lawrence versus Texas. Those cases have been the most controversial cases in all of constitutional law, largely, and the target of conservatives for the last 30 years who have alleged that the entire doctrine of substantive due process is without rooting in the text and history of the Constitution. Well, if you look at the text and history of the Constitution, and on that topic you see straight in front of you the Privileges or Immunities Clause, which was intended by the framers and says is about protecting substantive liberties and substantive rights of Americans. And so this whole conversation we've had for the last 30 years about whether judges have a responsibility, have a role in protecting substantive liberties, has been a conversation that's been devoid of and taken place without the text and history that was supposed to be the center of that conversation and mandates that judges have a role in protecting the substantive liberties.
Okay, so let me now give everybody a second before we turn to questions to give just a couple of sentences focusing on things like Justice Sotomayor joining the court, the guesstimations about whether Justice Stevens might be leaving, Obama, SG, forward-looking, big picture, something that you think people should keep in mind that seems interesting to you. And so if you didn't mind, Deanna, can we start down there with you?
Well, if Justice Stevens should retire, I think any short list of qualified candidates would include some highly qualified women, including, I expect again, Solicitor General Kagan, who will be only more qualified. And it's a very intriguing thought, to me at least, that there might be 3 women on the court.
If Justice Stevens were to retire, I would be very sad. I clerked for him, and I can't really think of anything good that would come of that. People have talked a lot about his role, and one thing that I think people have talked less about than they should be is his role in oral argument. I think in recent years, oral argument has maybe devolved a little. It is more often somewhat self-indulgent. And Justice Stevens is really, he's the last practitioner, or at least the primary practitioner of sort of old-style questioning. The questions are not designed to show how much smarter he is than everyone else. They're not venting because he's mad at something. They're not even usually to make a strategic point for another justice. They are what we think of in ordinary parlance as questions, and he wants to hear, he would like to hear an answer. And I do think that he is the best role model on the court right now for that kind of restraint, and that his departure, if it were to happen, would be a significant loss on that score as well.
Let me just begin by echoing that. I think Justice Stevens is a classic old-style judge. I probably disagree with him, 90% of the time, but very smart lawyer, actually wants to engage with you intellectually, doesn't get annoyed, actually kind of likes it if you give him an answer that he hadn't thought of and stuff, and I think he will be missed at oral argument if he's not there. The only other thing, I guess, is the blazingly obvious point that over the next 2 or 3 years, we'll see whether or not the replacement of Justice Souter with Sotomayor, where it's going to affect. I think we all have a general sense that it might be in these cases, for example, these confrontation clause cases we're talking about, create some uncertainty. And my parochial focus on separation of powers, where actually Justice Souter had been a relatively muscular proponent of separation of powers. I suspect strongly Justice Sotomayor is a relatively blank slate on that. I haven't seen any opinions from hers where she's even dealt with the issue. So that'll be another sort of interesting area to watch.
Lisa?
Well, the interesting about Sotomayor coming onto the bench is she was a prosecutor. And one of the things that we've seen before, it was at the argument a couple of years ago, there was a Snyder argument, which was argued by Steve Bright, the president of Southern Center for Human Rights. And what was so apparent during the argument was This was a death penalty case out of Louisiana, was just the importance of having somebody who can actually bring a trial court into the Supreme Court. You're in this incredible space, and the ability to actually bring the day-to-day reality of what happens in a trial court in some of these southern states is something that's very difficult to do. Sotomayor was not didn't practice in some of these courts, but she was a prosecutor, and I think in some ways we're holding our breath to see which way that cuts. But she's certainly going to have influence in that way as a practitioner.
Paul?
I think it's interesting, looking forward to this term, to think about this Citizens United case, which if it goes the way everybody sort of thinks it will, and I think it will, it's going to have an enormously transformative effect, not on the First Amendment, but on the election system of this country. This is really an election case, much more than a First Amendment case. And here we are, if you put that in a broader context, 9 years later for Bush v. Gore, when the last time the court took a really muscular approach to interpret the Constitution, to come in and intervene and change the outcome, there in a particular election, but here really to shift the balance of power very dramatically towards certain interests and away from others in the way elections are going to be fought out in this country. It's very strong merits arguments, I admit, but it is going to make an enormously transformative effect. And if you look at the record of the court, and if I were advising them to be worried about their legitimacy, it's these election cases where their legitimacy is going to be most questioned. And if you look at the record of the last 9 years, there's a number of cases where Democratic, liberal side electoral interests were brought to the court, and every one of those has lost. Partisan gerrymandering cases, these are all cases I lost. That's why I was talking about the voter ID case. But in between, you have the bookends of what's going to be Bush v. Gore and Citizens United, in which the court is going to be very aggressive about overruling past decisions in Citizens United, taking an equal protection position in Bush v. Gore, which is obviously problematic, to interfere very dramatically in the electoral system. And the court ought to be worried, I think, about where that goes, because Citizens United is not going to be the end of this process. It leads to a whole bunch more stuff in the campaign finance area, and who knows what the ending is. But deregulating the entire campaign finance machinery is going to have an enormously transformative effect on the way elections are run, with some people gaining and other people not gaining. So it's interesting.
Yeah, just picking up from where Paul left off, I think there's a lot of focus now, understandably, on where Justice Sotomayor will change the court, or how she will change the court. And I think, really, though, what we're seeing in Citizens United and other cases this term is how much the changes of 2005 and 2006 have affected this court. And it's just something you see over time as cases filter up to the court. Citizens United is probably the biggest that we've seen so far. If it goes away, we expect it to. And so I think, and my Constitutional Accountability Center released a report today that previews the big cases of this term and explains this in more detail. But I do think this term is going to be an enormous test for Chief Justice Roberts and the conservatives on the court about there are in Free Enterprise Fund, in Citizens United, in the guns cases, these dramatic changes in the law that are being urged upon them, and how they handle those, what principles guide their opinions, if any, and whether they follow originalism, whether they follow minimalism, whether they follow the result-oriented path of least resistance to a conservative end. And I think that's the test that we're going to see answered over the course of this term. I hope I'm proven wrong in my cynical view that we will see the last of these outcomes.
Do we have a microphone for folks who are going to ask questions? Terrific. And so we have about 8 or 9 minutes for that. And so maybe we can. Yes, ma'am. And if you could identify yourself first, that would be great.
Excuse me, I'm Penny Starr. I haven't spoken for so long here. With CNS News. I wanted to ask Lisa Kong about, you brought up Sullivan versus Florida. And in that case of the 13-year-old specifically, he was convicted of raping a 72-year-old woman. And the other, there's another case in Florida, too, and that involved armed robbery. But both of those, as you mentioned, were not homicide cases. But there are homicide cases of under 18-year-old individuals who have committed heinous crimes. And I wondered if that should be considered when looking to Roper, the execution, but if a life sentence should remain an option on the table depending on the crime.
Right. I mean, I think what's interesting about, you're trying to read tea leaves with two tea leaves. It's hard to see what the court was thinking, but they granted cert to a 13-year-old non-homicide case and a 17-year-old non-homicide case so quickly after Roper, which came out around the death penalty under 18. So, the question is, how is the court going to cut this? And in the most hopeful version, they were going to take the reasoning behind Roper and find that life without parole for any child under 18 is prohibited by our ban on cruel and unusual punishment. That might be asking a little much of this court, but it's the reasoning underlying that is all solid, is all there. It's all contained in the Roper decision.
Thank you, Richard Salmon with Kiplinger. For Deanne Maynard, on the NFL single entity case, I understand how you described it, but you also said that there could be ramifications beyond sports franchises. So if I were to pick something like McDonald's, where there's a lot of franchises, and there might be an agreement that we're only going to use this paper company to make soda cups at all McDonald's franchises, is that even in the realm of a decision in this case, if you say it may have ramifications beyond?
Well, I know there's specific franchise law, so can I take it out of your hypothetical, or just
yes.
That violates all rules of oral advocacy? But since you're not an Article III judge, I think it could affect any type of business joint ventures, including contractual arrangements, where one company decides with another company that they are going to undertake a joint venture, do something together, that but not completely merge or not be a complete parent subsidiary like in Copperweld.
Right.
And that if the court, depending on the court's reasoning, it could mean that in doing those activities, the two companies are a single entity for Section 1 and therefore couldn't be guilty of conspiring within the meaning of the statute. And so depending on how the court reasons it, because they could try to limit it to the sports league context, and they may well try. But however they get there, lawyers are going to argue that it applies. The reasoning would carry over outside that context.
All right, thank you. And just very shortly on campaign finance case, since that was technically part of the last session, can we expect that to be decided, in the next few weeks or the month, or?
I don't think there's any guarantee. I mean,
No.
They may try to get it out before the new term starts, but that would, I think, depend on them having the opinions almost drafted in the spring. And I just don't know if that's the case. I don't think anybody does.
In the back.
My name is Mark Sheff. I'm with Crane's Workforce Management Magazine. In recent terms, we've seen important labor and employment cases like Ledbetter and Ricci. And I'm wondering, in this term coming up, is there a case that reaches that level? And if not, what are the most important one or two labor and employment cases?
Yeah, exactly. Is the true answer. The court has really. Right. And that was Robin Conrad of the U.S. Chamber of Commerce. Thank you. Who would know? And I would say the other case that implicates the same sorts of interests may relate to attorney's fees, where the court is going to tackle across a wide range of federal statutes whether you can have multipliers on attorney's fees. That's principally in the civil rights context, but it extends more broadly. Other questions? Yes.
Bob Ritter with the American Humanist Association. Earlier at the outset, you talked about Salazar versus Buono. I was wondering if the panel has any thoughts on the concept of whether or not the court will maintain the unwelcome contact with a religious symbol, or whether it will seek to overturn longstanding precedents like the Stone decision and others.
Do you want to talk?
Does anybody else know?
I think that's the thing to look for in that case. I think the case lends itself to very fact-specific, narrow solutions, one way or the other. And I think that comes from what Paul was saying. All of their cases in this area tend to be fact-specific, context-specific. Clearly here, there are very narrow arguments being advanced, both on standing and the merits. But I don't know. That's what I'm looking for in that case. Are they going to decide it on the narrow grounds that are sort of most easily served up and taken, or will they use it to make a big dramatic departure, either in the standing context, something like if there's no coercive effect, if you can just, it's not on a classroom wall, you can just turn around and not look at it, you don't have standing, or on the merit side, so long as the government doesn't own the land under the display, we don't see a problem. I think it is more likely to be decided on narrow grounds, but who knows?
The one thing I would add is that this is an area where you would expect, in the wake of the departure of Sandra Day O'Connor, that this court is primed for significant doctrinal moves. It may not be in this case, but this was an area in which she was a real limiting agent, along with, for example, race. And we've seen some movement there. Along with campaign finance, we are likely to see movement there. Religion is coming in this case or another one.
And it's also an area where I think the change of administration makes something of a difference. And the government's briefs in this case are mostly about the narrow points. I don't really see the government in any kind of full-throated way, inviting a very broad ruling here.
Hi, Elaine Middleman. I have benefited from several recent seminars about Citizens United and the shrinking cert pool, and it seems like maybe there's a theme here that instead of focusing on the effect of Justice Sotomayor, it would be what the restructuring of what the question presented is by Chief Justice Roberts, Alito, et cetera, that a lot of these cases that seem to be settled law, in fact, they're kind of being reopened or recut like the Hope Diamond or something.
Well, one thing that's kind of interesting in the Guns case is the question of whether they take the entire question presented. One way they could get out of the kind of tricky privileges or immunities question that has been presented is to just grant the due process incorporation question, and we'll see if that works both ways. But obviously, in the Citizens United case, it was a fairly narrow case in the spring and has become a much broader case because the court didn't change the question presented. They just presented a new one and ordered briefing on it.
All right, so it's 2 o'clock, and we're going to stop right on time, but you should feel free to come up and ask the panelists questions. Please join me in thanking you.